Hello and welcome. This media recording accompanies the course Political Science 4501 and 5501, taught by Dr. Greg Dixon of the University of West Georgia's Department of Political Science and Planning. This media recording and all course materials are copyright 2014 by Gregory C. Dixon, and all rights are reserved. Students, staff, and faculty of the University of West Georgia have permission to copy, transfer, or otherwise use these recordings for nonprofit educational purposes. This lecture is about the nature of contemporary international law. We're going to talk about sort of the underlying principles behind it, and also we are going to sort of discuss some of the challenges that international law faces as distinct from domestic law. This is one of those lectures where there will be more Latin phrasing than usual, so I'm starting off with a note on vocabulary. Latin is really cool. It's one of those things that's a holdover from the period in which all intellectual discourse was conducted in Latin. It does sound smart when you can use Latin phrases, although fewer and fewer people understand what any of those phrases are. It can also scare people because people don't know what you're saying, and it has a sort of mysterious element to it. There's sort of a visceral cultural holdover from a period in which Latin was the language of the church, and the church was the only thing that stood between you and eternal damnation. In law school, if you go on to law school, you'll memorize a lot of Latin phrases, mostly so that you can scare people with them, because the idea, of course, is that to be a lawyer, you have to memorize all sorts of arcane knowledge, and arcane knowledge in Latin is even scarier than arcane knowledge in English. So in law school, part of your ongoing effort to instill fear in people is memorizing lots of Latin. It's also a great way to narrow the range of people who have a particular set of skills, and this is equally true in academia and law school. So if I poke fun of law school periodically in here, don't worry. Academia in general can be equally mocked as we go along. In this class, I will relatively rarely use Latin, partly because I don't speak Latin, and my pronunciation of Latin may or may not be accurate. I will use it when it's appropriate and when the terminology fits, particularly for certain concepts that are kind of key and commonly referred to using the Latin. That's where I will use the Latin phrasing. I do not expect you, for the purposes of my course, to memorize the Latin phraseology. So I use it because generally that is the appropriate way of referring to some of these concepts. But in this class, I do not expect you to memorize the Latin, although if you do intend to go on to law school, if you intend to study international law, you should do so. One of the biggest things that we want to think about in terms of international law that make it distinct from domestic or municipal law is the fact that there is no single source of international law. It is what we call decentralized, meaning there is no central authority, there is no central body, there is no source of law. In a domestic political system, the central government, whether that government be democratic or authoritarian or something in between, that government is the source of law in the particular country. And this is true in a legal sense regardless of what other sources you might hold up. In countries that are predominantly Islamic, that do not have a separation of sacred and secular, you may have the Quran as the sort of moral foundation of the legal system. In some countries who try to practice a strict version of Sharia, you have a direct link between the Quran and law. In the West, for most of its history, until the last 150 to 250 years or so, you had a direct link between the Bible and law. In fact, we still, to this day in the United States, have these kinds of linkages. In many places in the South, you have laws about the sale of alcohol on Sundays. Those are derived from the Bible. So the derivation of the law in a moral or historical sense is separate from what we mean when we talk about centralization or decentralization. When we talk about centralization or decentralization, we're talking about the enforcing authority and the authority that establishes for the principle of day-to-day operations what is a law that must be obeyed by a citizen of the polity regardless of all of the other elements that come in. So if you are a Christian, a Hindu, a Muslim, a Jew, if you practice no religion, if you are a pantheist and practice all religions, none of that matters if you're in the United States, because you still have to stop at a stop sign. You still are not permitted to simply walk down the street and murder somebody, because there is a central law in the United States that derives from the government, and the government enforces those laws. The problem with international law from an enforcement perspective and from a simplicity perspective many times is that there is no single source. And because there is no single source of law, there is much greater scope for disagreement over what international law means. There is no single judicial body to interpret international law. There is no global government. There is no global third party to enforce international law. So, in the absence of that kind of a judicial body there to interpret international law, we oftentimes have to fall back in international law to other forms of enforcement and other forms of interpretation. In American law, we may disagree over what a law means, and we solve it by the great old American tradition of suing each other. When we look at the Affordable Care Act, also known as Obamacare, and it mandates that all Americans buy insurance, whether they want to or not, and some Americans say, that's unconstitutional. You can't force me to buy some random product, whether I want to buy it or not. Well, we sue. We go through the courts. And the Supreme Court, the highest court in the U.S., ultimately rules. And in the Affordable Care Act case, they ruled that, yes, the government can force you to buy products, whether you want to or not. And in doing so, sets a firm precedent. The Supreme Court has ruled, it is the legitimate ruling body, and that now is the law of the land, and the government will enforce it. In the absence of a single judicial body, there is no way to get that definitive ruling. Similarly, there's no executive to carry out the terms of international law. So the United States has an executive branch headed by the president that carries out the laws of the land. So the Obamacare Supreme Court ruling comes down. That means that the government can, in fact, force you to purchase things whether you want to or not, and can impose upon you. The government can force you literally, ultimately, by force of arms, using physical violence against you, to make you do what it wants to do. Now, in the Obamacare situation, the IRS is going to force you to buy health insurance, or you will pay a fine. And you will pay a fine by, at the end of the year, in your taxes, having a penalty applied in your taxes at the end of each year. So, in the United States, failing to get health insurance doesn't immediately lead to people kicking down your door and forcing you to go on the insurance exchange and buy health insurance. But if you do not buy health insurance, you will have to pay a fine, a fairly substantial fine, although still lower than the cost of health insurance in most cases. So in this case, there is an executive branch that carries out and enforces the law. But there is no equivalent at the international level. So in the international system, there is no equivalent of the executive branch. One of the interesting things then is when we talk about decentralization, almost everything that you're used to thinking about in domestic law, all of these key elements, a legislature that passes a law, an executive that enforces the law, a judiciary that interprets the law, none of those things are present. There is no legislature, there is no executive, there is no single judicial body, there is no hierarchically ordered set of institutions to determine what exactly law says and how to carry it out. So One of the biggest things that confuses people sometimes in looking at international law is this decentralization. It's the complete lack of any single source or single enforcement body for international law. Well, this is a problem in a lot of ways, because when we think then about how we're going to go work out international law, there is no single source. And without a single source, that means it's almost impossible to create a system in which international law is universally binding. Law in international law is not universally binding the way law in domestic law is. In the United States, 100% of the people in the country are bound by laws against murder and violent assault and so on. In the international community, there are elements of law that not all states have to follow, because not all states have signed on to those treaties, and not all states agree on how those treaties are interpreted. As an example, in recent current events, the nation of Russia had sent troops into the Crimea, which is the territory of the Ukraine. Those troops essentially split the country away. They oversaw a referendum in which the Ukrainians surprisingly voted in the Crimea to become part of Russia. Well, when you have 50,000 Russian troops in the territory, it doesn't really surprise very many people that you would vote to do what the Russians want you to do. And Russia immediately then annexed the Crimea. Now, this would seem to be a very clear violation of international law. The Ukraine is a United Nations member state. Russia is a United Nations member state. It looks on paper, or when you describe the circumstances, as though Russia invaded the Ukraine and annexed part of its territory. This is a fairly clear violation of international law, of the United Nations Charter, except that not everyone agrees on the interpretation, and there is no body to ultimately make that determination. So Russia does not agree that this violated international law. Russia said, oh, well, the Crimea historically was part of Russia and had historic ties. The Russian-speaking citizens there were being repressed, and they have a right to self-determination, which is also in the United Nations Charter, and that they freely exercised their right of self-determination. And this is a conflict over interpretation of law. And even though in this case, all of the respective parties had signed the same treaties, there is no agreed interpretation of the law. To the Russians, the people of the Crimea exercised their right of self-determination. They joined Russia, and that's the end of the story. To the Ukrainians, and to most of the rest of the world so far, the Russians illegally invaded and annexed the Ukraine. Invaded and annexed a portion of Ukrainian territory. And it still remains to be seen how this will play out in the long run. It's difficult to see how, at least without a war, the taking of the Ukrainian territory will be reversed. But we don't really know. It's too hard to tell. But it's certainly clear that in this case, there's no desire by countries other than, well, actually, nobody really, to challenge the Russian interpretation of the law in a meaningful way. While there's a lot of talking, there's not really any action to do that. And so what we've seen is, because law is not universally binding, for something as basic as a disagreement over interpretation of a law that everyone has signed, this is a problem of decentralization. There's no definitive interpretation. You can't go to a court and say, hey, what Russia just did is illegal, make them stop. Even if you could find a court, the International Court of Justice, say, the International Court of Justice could rule that the invasion and annexation was illegal, but that court has no enforcement power. And I've kind of picked on Russia here in this example, but the International Court of Justice ruled in the 1980s that various acts of the Ronald Reagan administration with respect to countries in Latin America, and in particular the mining of Nicaraguan harbors, the International Court of Justice ruled that these were illegal, that these were illegal acts under international law, and the Reagan administration essentially said, that's nice, screw you, we're doing it anyway. And that's a problem. And it was fairly clear under international rules that the mining of these harbors was in fact illegal because it endangered civilian shipping as well as military shipping, and it was indiscriminate. It was basically illegal. There's no declared war, and so covert actions like this are illegal. But there was no way to punish the United States. The sad truth is that most countries will violate these kinds of rules at some point. So I could give lots of examples, but I will pick on the US and Russia a lot just because for the period of the Cold War in particular, they were the two largest countries. So where do we get international law if it's decentralized and we lack all of these other key elements? Well, the International Court of Justice, which is the closest thing we have to a global court. Sometimes people call it the World Court, but its official name is the International Court of Justice. It sits in The Hague, and they are the highest body in the United Nations system for hearing these sorts of cases. And International Court of Justice rules draw international law from 5 separate sources. The first are international conventions. The second is international custom. The third is actually one of these things that's kind of interesting. It's general principles of law recognized by civilized nations. And the fact that the civilized is, in this case, spelled with the S rather than the Z should tell you that it originally derives from a British interpretation many, many years ago. Judicial decisions, that is judicial decisions both at the international and domestic level. And expert opinions from national jurists. So these 5 areas are where the International Court of Justice derives its international law. Now, this is a very important set of concepts and a set of principles, because what this is going to mean is when we talk about international law and we look for a way of sort of feeding through all of these different sort of questionable zones to find something that we can say really fits what is accepted as international law, this is essentially what we're going to fall back to. These 5 criteria, because it's the closest thing we have to an internationally recognized set of principles from a legitimate body. Now, it's from the United Nations system. It doesn't bind everybody, but it's the closest thing that we have. When we say international conventions, what we're talking about are essentially treaties. These are formal agreements between states. This is very important because these are formal documents. They are documents that are signed and ratified through an accepted legal process internationally and in the domestic politics of the various states. So in the United States, the president can sign a treaty, but that does not bind the United States to it. The president must sign the treaty, and the Senate then ratifies the treaty with a 2/3 vote. So in the United States, for the United States to be bound to a treaty, the president must sign and the Senate must ratify. Now, this is a very important thing because presidents will sign treaties with the full knowledge that there will be no Senate ratification. So a president might sign a treaty for political purposes, knowing that there will be no ratification. Bill Clinton signed the Kyoto Protocol on climate change, secure in the knowledge that the Senate would never ratify it. And because the Senate would never ratify it, that meant that he could sign the Kyoto Protocol, get the benefits of saying, look, I'm in favor of climate change, and yet he wouldn't have to pay the consequences, pay the material costs of actually complying with the treaty. And what we see is that various presidents will sign and unsign, because you can unsign a treaty for political purposes, and the Senate may never ratify. It's important to note that even Bill Clinton, when he had Democratic majorities in both the houses of Congress, never even tried to get the Kyoto Protocol ratified. And it was one of those situations in which it was good for everybody to be able to claim that the Democratic Party was in favor of the Kyoto Protocol without actually having to put it into place, because it would have cost American businesses a significant amount of money and cost American jobs to comply. So it was a political ploy. Now, there's a problem then, because what that means is the United States may be in a situation in which there are international treaties that the majority of countries actually are in favor of, but that cannot overcome the two-thirds majority in the Senate. And there are examples of this, such as international treaties against landmines, where most countries in the world have said, landmines are a bad thing. They stick around a long time after conflicts. They're a big problem. So countries should not use them. And the majority of countries in the world have ratified a convention against landmines, but the United States refuses to do so. We have neither signed nor would it have a snowball's chance in hell of being ratified in the Senate. And so the United States sometimes ends up on the sort of negative end, and there's a whole series of conventions that's true for. The key for us, though, is that international conventions bind the signatories to the rules of the convention. So when you sign and ratify a treaty, you become bound by its rules because you have agreed to be bound by its rules. And here's one of these Latin terms, pacta sunt servanda, is the term. Agreements are binding on all parties. Basically, if you sign a treaty, you are obliged to live up to your obligations under the treaty. And so if you sign the Nuclear Non-Proliferation Treaty, then you have a right to engage in civilian power projects, so you can build an atomic reactor for the purpose of power, but you cannot pursue a program that can be used for weapons. And the same is true for other conventions that are out there. Anything you agree to, it's binding. If you join the World Trade Organization, you have to follow certain rules. If you violate the rules, there are means of punishing you within the World Trade Organization. So pacta sunt servanda, agreements are binding on all parties. And international conventions can be really short, or they can be insanely long. The World Trade Organization, the actual Treaty of Marrakesh that creates it, is a fairly long treaty, but it's also, it's supplemented by tens of thousands of pages of international trade law. So the World Trade Organization is an especially complicated treaty. Other treaties are very short. The North Atlantic Treaty that gives us the North Atlantic Treaty Organization, NATO, is shorter. The European Union treaties are also quite complicated. They have a whole set of laws that go along with them. But international conventions bind the parties, and if you want to get out of having to comply, you have to leave the treaty. And most treaties do have a mechanism for withdrawal, so countries can leave once they're in. International custom is actually very interesting because it's how things are generally done. There's no treaty, but it's how states act. The material fact of state behavior. Now, material fact is an important term because what it means is not what states say, but what they actually do. So the focus here is on how individual nation states normally act. So in a circumstance where nation states have basically done some particular thing for however many years and decades and sometimes centuries, what happens then is that common practice comes to be seen as obligatory. And here comes some more Latin. Opinio, juris, sive, necessitatis. And what that essentially means is a state has been acting as though a certain way of behaving is obligatory, so therefore it is obligatory. There may not be a treaty, but because all of the various nation states act as though they were supposed to do something, they are bound by that. Now, this is something that can be really complicated because there are lots and lots of smallish examples of this. The idea, though, is that states generally behave in a particular way. So since the end of the Second World War, states have followed what we call the norm of non-conquest, meaning that you simply don't invade another country, seize their territory, and take it and add it to your own country. Now, it's important to note that part of that has to do with the UN Charter. Aggression is illegal under the UN Charter, but part of that is normatively, nobody has really tried to do so. You can count on one hand, with a couple fingers missing, the number of times when one country has literally invaded the other and seized its territory. Tibet is one example of that, and really the Russian invasion and annexation of Ukraine's Crimean region is the other big example. There are a handful of small examples of this, but generally speaking, those are the two big ones. The Tibet situation is the one really kind of large-scale one involving major powers until recently. The norm of non-conquest is important because what it means is that countries like the United States, when we engage in something like the Iraq War, unlike the colonial period when we would have simply seized the territory and then run it as a colony, we don't do that. We go seize the territory, set up an independent government, and then go home. And this changes how countries act. But what's interesting then is it also creates a set of obligations. Countries act in a particular way, therefore that action becomes something that is understood to be required. The United States did not need to go to the United Nations to get permission to invade Afghanistan. Under international law, it didn't matter that Al-Qaeda was a non-state actor. Essentially, you would look at 9/11 as an attack by Afghanistan on the United States. We have our rights under the United Nations Charter to simply respond, to defend ourselves against Afghan aggression. And we didn't need UN support, but we went to the UN anyway. Why? Because it is the general practice of law that countries go to the United Nations. We act as though it were an explicit obligation, even though it's not. The problem here is that this is really vague. This is really vague. It's not as vague as some of the other ones we're going to talk about, but it's pretty vague. International custom. What is international custom? How long do states have to act a particular way before things become obligatory? And there is no answer to that kind of question. The interesting thing here is what we see is that the rule of international custom in the international system is very similar to what has been observed, or at least theorized, to be the kind of process that we see in early human societies, where practice, how things are done, tended to rule. In small-scale hunter-gatherer societies, tradition and how things have been done in the past is an extremely important mechanism for holding society together. And in the absence of a system of sophisticated laws, and in a community of only a few hundred individuals, what we see is that there's a whole system of obligation based on practice. And in international law, that is something that we see as well in a case where we have only a few hundred actors, a little over 200 actors, in fact, all acting in an environment with no single body that has legitimate authority to bind them together. So international custom, interestingly, has this resemblance to the evolution of early human societies back in the day. Although we do extrapolate to what those were like based on societies that we've observed in the modern era. Well, if you thought that last one was vague, general principles of law. This one's vague too. This is really an interesting one because it is the way law is generally interpreted. Now here, this is interesting because the first things that we've been talking about are international. A state signs a treaty with another state. How do states actually act when dealing with other states? Now here what we're talking about is something that crosses into domestic law. the way law is generally interpreted, in this case by international courts or by domestic courts. And so if there is a way that countries everywhere pretty much seem to interpret law, that fits here, general principles of law. Now, what's interesting is that this is how civilized nations apply law. And this is a holdover from the colonial period. If you think back to the late 1800s, there was this idea of civilized nations and uncivilized nations. And the only thing that really mattered was the civilized nations. You didn't want to hold on to the sort of barbaric ways of doing things. You wanted to be a civilized nation. And so one of the things is that this is a very, very kind of contentious way of thinking, because it does still kind of divide the world into civilized and uncivilized, which particularly in academia is considered to be, trying to think of the polite way of saying it, it's considered to be bad. We're not supposed to say we're civilized and they're not. But this ultimately is a holdover from that kind of a period. And what we're essentially saying is that countries that are team players and good buddies in the international system act in a certain way and think in a certain way, and that is the way that everybody should act and think. The idea is that the International Court of Justice, when it looks at law, will follow the kinds of rules that countries like the United States, the members of the European Union, will apply in their legal systems. And so you want to follow law as it's generally practiced. The problem is this is really vague. And who's a civilized nation? Well, is Russia a civilized nation? They have rule of law. They've had a distinct civilization for a very, very long time. But is it a civilized nation? They've invaded and annexed a neighbor. The first time it's happened since the World War II era for Europe. Is that a civilized country? Do Russia's actions, does the practice of Russian law fit this idea? And the answer is we don't know.